Good afternoon. Today I'd like to talk to you a little bit about the law in Texas surrounding driving while intoxicated, or as we frequently call it, DWI. First of all, DWI means this: person operates a motor vehicle in a public place while intoxicated. Intoxication is proven one of two ways, or both: loss of the normal use of a person's mental and or physical faculties, or having a breath or blood alcohol concentration of 0.08 or greater. That's what DWI means in the state of Texas. We do not have a separate provision in the state of Texas for driving under the influence, or DUI, as people frequently refer to it. We have driving while intoxicated, and those are the elements that I've just listed for you. Driving while intoxicated is one of the ever-changing, most complicated types of cases that we receive in this office. Whether it is a Class B misdemeanor, DWI for a first-time offender, or whether it is an intoxication manslaughter case that is a 2 to 20 second-degree felony. These cases are serious and they are extremely complicated. As a matter of fact, it is frequently the case that I have tried murder cases that were much simpler in terms of the evidence and the expert testimony than DWI cases that I've first offender, Class B misdemeanor DWI cases that I've defended. The moment you're arrested for a DWI, it sets two separate processes in motion. The first one is what you're thinking about. It's the criminal case against you. The penalty range for a DWI is up to 6 months in the county jail and up to a $2,000 fine. The second time around, it doubles. $4,000 fine and up to a year in jail. And after that, it becomes a third-degree felony, meaning 2 to 10 in the penitentiary and up to a $10,000 fine. But there are also all different types of aggravating factors that can change the range of punishment and can change the potential outcome in the case. That's the criminal side. On the other side, we have to deal with the Texas Department of Public Safety and its administrative license revocation system. Because at the time you're arrested for a DWI, one of the things that the officer is going to do is talk to you about submitting to a breath or a blood sample. If you take that breath or blood sample and you blow or test with your blood higher than 0.08, then your license is going to be suspended. As a result of that proceeding, your driver's license will be suspended for a minimum of 90 days. If you refuse to do one of those tests, then your license can be suspended for up to 180 days. But depending on what your history has been and other previous contacts, your license can be suspended just on the administrative side without regard to the criminal case. Your driver's license and your privilege to drive can be taken away from you from anywhere between 90 days up to 2 years. And in some instances, you are not able to get what we call a restricted or occupational driver's license from any judge. So those two things immediately get set in motion from the moment of arrest. It is critically important because of the complicated nature of these cases, the varying degrees of scientific evidence, expert witnesses, and the constant state of change of the law for you to be represented competently and well in a DWI case. If you, your friends, your family, or anybody that you know, care about, your coworker, have an experience with being arrested for a DWI, you need to call us here at Dee McWilliams.